Hi, everyone, and good evening. Thank you so much for joining us tonight on part 3 of our 4-part mini webinar series talking about different estate planning documents, why they're important, why you should have them. We're going to wait maybe just another minute or two for everyone else who's joining us. We'll get started in just a few moments. My name is Lauren Burns. I'm a senior associate at SJF Law Group, here co-hosting with Jenny Lamb, our marketing director.
Hi, everyone. Thanks for joining tonight's webinar.
So tonight we're going to be talking about durable powers of attorney. This is, again, part 3. We've already talked about trusts and healthcare surrogates. Next on the list is going to be wills. I'm also hosting that event a week from today. That'll be our 4th and final part. So with that being said, why don't we get started? A little bit about our firm. So we practice estate planning, probate, and trust administration. We work with clients on everything to putting together an estate plan, doing the planning at the beginning, and then administering either their trusts and their plans that they put in place, or helping with probate administrations, where assets go through the court process. We help with all those 3 areas, everything in between. So let's start first with what is a durable power of attorney. So this is a document that you are going to sign and execute that names someone to make financial decisions for you if you're not able to make them for yourself. So this is for things like helping you pay bills, speaking with your insurance companies, drawing money from the banks, signing checks, filing income tax returns, things like that. So your durable power of attorney is a financial document. It's giving someone authority to act on your behalf with respect to your finances if you cannot make those decisions for yourself. Before we keep moving on, I do want to mention that we're going to have a few polls throughout this presentation, so keep an eye out for when those questions come up. We're also going to provide a handout at the very end, so stay tuned for more on that. When we talk about a power of attorney, let's talk about who the players are. So who are the people involved? Who are the parties? You're going to have your principal. The principal is the person signing the power of attorney. This is the one who's granting someone else the ability to act on their behalf with respect to finances. So this is the person who's granting the authority to someone else. The agent, on the other hand, is the person to whom that power has been appointed. So this is the one who the principal is naming to act on their behalf, make decisions for them. This is the appointed person in the document. We have a tip here that you should always name successor or alternate agents. Sometimes I meet with clients who have powers of attorney either prepared by other attorneys or they did their own form, and sometimes I see that they only have one person named as an agent, and that's not good practice. Just in case something happens, if they pass away or they become incapacitated, or if they just don't want to, they don't want to serve, you definitely want to make sure that your document names an alternate person in case, for whatever reason, that primary person that you name is not available or willing to serve in that capacity. So I'm going to jump back here. Jenny, I think this is a good time for our first poll. So Jenny is going to get that out here, our first poll. If I become incapacitated, my spouse, and this is a true-false question. So if I become incapacitated, my spouse can make decisions for me even without a power of attorney because we're married. True or false? Right now we have a split opinion. Just a few more seconds. So we have all of our answers in. It looks like the majority has selected false, which is correct. So just because you are married to someone, your spouse doesn't automatically have rights as your spouse to make decisions for you. Without something in writing, without a legal document appointing someone to act for you, even spouses can't automatically step in and do those things. So very important document to have for anyone, spouses, if you're not married. So that's a good segue into our next slide, which is why should I sign a power of attorney? First, unforeseen circumstances. We all never know what the future holds and what is going to happen. You want to be prepared so that you have someone with authority to act for you if something happens and you can't decide for yourself. Point number 2, without a power of attorney, no one has legal authority to act on your behalf. So even spouses, we just went over that in our poll. Having a power of attorney can also help avoid a guardianship. Guardianship is appropriate where someone is not able to make decisions for themselves and the court becomes involved to appoint a guardian for that person to help them with medical and financial decisions. Guardianship is a process. It's a court process. It can be time-consuming and expensive, and sometimes what happens in a guardianship is the judge appoints someone to act as your guardian that maybe you didn't want, or maybe that you wouldn't have chosen if you had perhaps done a power of attorney while you still had capacity. Some other examples of situations where having a power of attorney may have been really helpful or may have prevented an unintended outcome or unforeseen circumstance is, take the example where a husband and wife owns a property together and one spouse is diagnosed with dementia and cannot act in their own capacity, and now the couple wants to sell the house. Without having a power of attorney, the spouse suffering from dementia is not able to sign for themselves, and their spouse can't sign for them. So you're kind of stuck in that situation. Another example is if you are a business owner and you have a business and something happens to you, your power of attorney would name an agent to act for you so that that agent can continue running your business, so that you can make payroll and pay employees, so that you have someone to continue business operations and make sure that that business stays afloat and keeps running even if something happens to you. One other example is if you're in, God forbid, a car accident and you become incapacitated, the agent that you name in your power of attorney would be able to handle legal matters related to that accident. They can deal with insurance claims, things like that. So powers of attorney become really important and helpful estate planning documents when you're faced with medical emergencies or progressive illnesses, accidents, mental health crises, you're traveling abroad and something happens. Lots of things can happen, and you want to make sure that you have a power of attorney just in case. Our next slide here, when does my power of attorney become effective? So this sometimes surprises people. In Florida, your durable power of attorney becomes effective immediately when you sign it. So some people think that, oh, this is only when I become incapacitated. So that's not the case. When you sign your power of attorney, your agent can act for you right away. It doesn't become effective when you become incapacitated. It becomes operative and in effect the moment that you sign it. Which brings us to our next slide here. What does the durable part mean when you say durable power of attorney? So the durable part means that your document remains in effect even after you become incapacitated. So if I sign my power of attorney today, I'm completely of sound mind, I have full capacity. If I later become incapacitated, The document survives my incapacity. So my agent is still able to act on my behalf. They can act on my behalf right now after I sign it, and they can continue to act if and when I become incapacitated. Creating a durable power of attorney. So how do you do this in Florida? Our first point here is always consult an attorney. Sometimes I see powers of attorney that are self-prepared and there's things missing or they're not drafted very well. So my advice is always to make sure that you are speaking with an estate planning attorney and that you have proper and competent legal advice when you are thinking about creating a power of attorney. As far as what it needs to contain and execution requirements, so you, the principal, has to indicate their name and address, state who they are, and identify themselves as the principal. The document also needs to have the names and addresses of your agents and your successor agents, your alternates. The document also needs to specifically list the powers and authorities that you're granting to your agent. So it needs to be very clear. If your power of attorney doesn't specifically authorize your agent to do something, then they don't have the power to do that. So you have to be very clear and very specific about what you're authorizing your agent to do and what power your agent has with respect to your financial decisions under that power of attorney. Number 5, statement regarding durability. So if you're making a durable power of attorney, it does need to have a statement that it is durable and that it's still in effect even after you become incapacitated. Proper execution, you need to sign your power of attorney, have it witnessed, and have it notarized. So those are all execution requirements together with what the document actually contains. That's how you could create a valid durable power of attorney in Florida. Our next slide here, common powers in a durable power of attorney. So I just talked about, your document needs to be very specific about what you're authorizing and allowing your agent to do. Some common examples of those authorities are banking, real estate, and investment transactions. So everything related to your banking, your financial accounts, real estate transactions, investment transactions, business operations. We talked about that a few minutes ago too. If you own a business and you would need someone to step into your shoes if something happened to you to continue running your business, your power of attorney would authorize your agent to continue those business operations. Tax matters, filing income tax returns, legal powers, so the ability to open and file lawsuits on your behalf, sign contracts. There are some estate and trust powers in the power of attorney that we'll get to in a few slides. Personal finances, government benefits, making gifts to qualify for Medicaid purposes or apply for government assistance, things like that. Insurance matters. So really everything financially related that you're able to do, you can delegate to or authorize your agent under your power of attorney to do those things for you. Before moving on to the next slide, Jenny, I'm going to ask you to present our next poll. So this next poll is not a true false, but it's a multiple choice. And this is just a question about what your biggest concern is about setting up a durable power of attorney. So some of our options here are choosing the right agent. Sometimes it can be hard to choose someone to act for you. It's certainly a big responsibility, so you want to make sure that the person that you pick is trustworthy and acts in your best interest. Another option is understanding the legal terms. There's a lot of information in these documents, so I can completely understand how they can be a little overwhelming. That's also why you consult an estate planning attorney to help you demystify some of those legal terms. Costs involved. Cost is always a concern. Another option here is potential for abuse. We'll kind of talk about that a little bit more in a few minutes. So just out of curiosity, seeing what your biggest concern is with this, because they're all valid concerns. Moving on to our next slide. So there are certain powers in your power of attorney. They're often referred to as the superpowers. These are authorizations and powers that for an agent to be able to do these things on behalf of the principal, the principal needs to specifically authorize the agent to do these things. They need to be separately initialed in the power of attorney because they're very powerful authorities. So the Florida legislature wants to make sure that if you are granting someone the ability to do these things, that you have separately initialed and authorized these things specifically. They're all listed in Florida Statute 709.2202. Some of the biggest powers under that statute I've listed here: creating an inter vivos trust. An inter vivos trust is a trust that you make during your lifetime, as opposed to a testamentary trust, like a trust that would come about under a will or something like that. Creating an inter vivos trust could be, as an example, a revocable trust, revocable living trust that you would make as part of your estate plan. Perhaps also a trust to employ some kind of estate tax mitigation strategy. Another superpower is amending, modifying, revoking, or terminating a trust that you already have. It's a big power. Changing the terms of your trust or revoking it, terminating it. Other superpowers involve making gifts, whether those are gifts for the annual exclusion amount, annual exclusion gifts, or gifts that exceed that amount. Creating or changing rights of survivorship. So rights of survivorship is a way to co-own real estate, for example. If you co-own a piece of real estate with someone as a joint tenant with rights of survivorship, it means that if something happens to you, if you pass away, that property goes by right of survivorship 100% to the other co-owner. So you can specifically authorize your agent to create or change rights of survivorship in a piece of property that you own. Also creating or changing a beneficiary designation. So changing or adding a beneficiary designation on a financial account or a brokerage or investment account. This oftentimes comes up when we talk about funding revocable trusts. Part of that is naming the trust as the designated beneficiary in your accounts. So this would come in if something happened to you, you became incapacitated and didn't get to completely funding your trust. You can authorize your agent to create a beneficiary designation on your account and name your trust as the beneficiary. So next here, how to revoke or terminate a power of attorney. Before we get into this one, Jenny, I would like you to share our handout. So I've created a sample durable power of attorney. I used Jerry Seinfeld and all of the other stars from the show as examples here. So this is a durable power of attorney as if Jerry Seinfeld was a Florida resident and named George as his agent. As alternates, he also named Elaine and Cosmo Kramer. So you could take a look at that just to get an idea of what it looks like, what kind of authorities are listed there, the power of attorney, what the signature page looks like, things like that. So you can go ahead and download that handout over there. How to revoke or terminate a power of attorney. So revoking a power of attorney, you can do a written revocation. This needs to be signed and notarized. So if you make a power of attorney and you say, okay, I want to cancel this, I want to revoke it, you can sign a separate revocation document specifically referencing that prior power of attorney, sign and notarize it. When you revoke your power of attorney, you should inform your agent that they no longer have the power to act because you've revoked their authority under that power of attorney. Also inform third parties. So you should inform your banks and any institutions that have knowledge that you have a power of attorney, and perhaps institutions where your agent has already acted for you. You'll want to let them know that you've revoked that power of attorney and it's no longer in effect. Terminating a power of attorney. Powers of attorney become void upon death, so they are only operative and in effect during your lifetime. Powers of attorney cannot be used after someone passes away. Sometimes powers of attorney will have a specified termination date. They'll say, this power of attorney is in effect until such and such date. Of course, when that date comes, that is the termination of that power of attorney. Sometimes a court order will specifically terminate a power of attorney. Another way that a power of attorney can be terminated is if the agent resigns or becomes incapacitated. So take the example I was talking about before, where you have a power of attorney that only names one agent. If that agent resigns and says, I don't want to do it, or they themselves become incapacitated, it's as if you don't have a power of attorney. You don't have any other documents, any other alternates, excuse me. And this could become very problematic if the principal is already incapacitated and not able to execute a new power of attorney, and the agent they've named is not available or unwilling to serve. Preventing misuse and abuse with powers of attorney. So this was one of the options in our poll, our second poll. It is a very important document, so it is certainly something that you want to keep safe and keep the original safe. We typically don't recommend giving out copies right after you sign it to your agents because of the fact that they can use it right away, even when you're not incapacitated. So typically, you know, you'd want to let your agent know, I've done a power of attorney, I've named you as my agent. If something happens to me and you need to use it and you need a copy, here's my attorney's information, reach out to them and they'll distribute a copy to you. So, but in the meantime, don't give out any copies. Do inform the people that you've named, and name someone that you trust implicitly. This is also sometimes not always easy for everybody, but certainly you want to name somebody that you trust implicitly and that you think would act in your best interest if something happened to you and you needed someone to step in to make these financial decisions for you. Before we conclude, if anyone has any questions, please feel free to drop them in the chat here. This recording or this webinar is being recorded, and this will be available on our YouTube channel. So if you have anything that you want to review again, you can access it on our YouTube and go through it. This slide here has all of our contact information. So this is our office phone number, our email, and our website. You can scan the QR code. That's going to bring you to all of our information. We have a lot of material on our website as far as blogs and articles, a lot of videos on our YouTube channel. So there's certainly a lot of resources available to you to help explain estate planning, the different documents, probate and trust administration, and any questions that you may have. And if there's something that you are still not sure about and you want some more information, please feel free to give us a call or send us an email. We're happy to talk about all of these things and answer any questions that you guys have. I want to thank you all for joining me tonight. I hope you learned a lot about powers of attorney. Again, if you have any other questions or something that you need some more clarity on or something that wasn't addressed in this slide, please reach out. I'm happy to talk about powers of attorney with you. Stay tuned for our last webinar next week, where we're going to talk about wills. If you have any questions or things that you want to talk about specifically before that next webinar, please send me an email and I'll be sure to include it on our slides for that next week. So again, thank you so much for joining us tonight. Jenny, if you have any closing remarks, please feel free to step in. Otherwise, again, everyone, thank you so much for joining, and I hope you learned a lot. Thanks for the opportunity to talk to you guys about powers of attorney, and hope to see you next week for wills.